Good afternoon. Thanks for joining us here today. Today we're going to talk to you about North Carolina's Unfair and Deceptive Trade Practice Act. And the North Carolina's Unfair and Deceptive Trade Act is probably one of the most little known, but probably the most important private cause of action that we have under our state in our state law. And from the outset, it was designed as good public policy to protect consumers in the transactions they conducted with sellers. The primary purpose of the act was to create a private cause of action for consumers, and it's codified in the general statutes as 75(1.1), and the statute says in pertinent parts that unfair methods of competition in or affecting commerce and unfair or deceptive acts or practices in or affecting commerce are declared unlawful. For the purposes of this section, commerce includes all business activities, however denominated, but does not include professional services rendered by a member of a learned profession. Any party claiming to be exempt from the provisions of this section shall have the burden of proof with respect to such a claim. And today, with this presentation, we kind of hope to take you through kind of the nuts and bolts of how the statute works and what you need to make a case using this type of claim. But most importantly, after we get through that kind of structured outlook, we really want to take you through some practical applications of how you can use this statute to your benefit in your practice in your everyday life.
And before we move on to the nuts and bolts, as Brodie was saying, this statute was codified to create a private cause of action for these sorts of things. And it should be pointed out that this cause of action exists independently, and it's usually tacked on to a separate common law cause of action. So therefore, it sits on top of and is distinct from actions of fraud, breach of contract, and breach of warranty, and other causes of action. Further, it is applicable to sales transactions under the Uniform Commercial Code, and it may afford relief even when the UCC doesn't. So just because something doesn't fall under bad faith of the UCC doesn't mean that you can't win an action under Chapter 75.
And before we move on, something I didn't say before that you should know is that courts tend to apply the statute very liberally, and that probably makes sense. And as we go through the course of the presentation, you'll see that for the good of public policy, you want to ban any conduct that could possibly be seen to be unfair or deceptive. So courts, when looking at these types of situations, tend to be very liberal with the statute.
So as Brodie mentioned today, we're going to go through some nuts and bolts of the statute, first being standing in the prima facie case, which does include a burden shifting scheme, and then we're going to cover what the judge and jury each part will decide, and then we're going to go through some damages before moving on to a practical application section.
Okay, so the first aspect of the outline we're going to cover is standing, and under the North Carolina statute, both an individual and the state can raise a claim for unfair and deceptive trade practices. Individuals can bring a private cause of action, which is mostly what we're going to be talking about today, but the state can also raise an action through the Attorney General, and if the action is brought by the state, the person could be subject to state criminal sanctions, but a person could also be subject to civil sanctions through the civil cause of action.
The second aspect is going to be about the federal law. Federal decisions under the Federal Trade Commission Act may be used as guidance by North Carolina courts in determining the scope and meaning of North Carolina's Unfair Deceptive Trade Practice Act. And as with all federal laws where applicable, the Federal Trade Commission Act will preempt the state law on unfair and deceptive trade practice.
So beginning with the prima facie case, there is a three-part test that needs to be met to win a suit. The three parts are: first, an unfair or deceptive act or practice; second, that act or practice needs to be in or affecting commerce; and lastly, the plaintiff's injury must be proximately caused by this unfair or deceptive act. So first, to define unfair and deceptive, although it is definitely hard to pinpoint what exactly it means, we're just going to give you some broad overview here. We'll cover some fact patterns later. So to be unfair, something needs to offend established public policy, or the act needs to be immoral, unethical, oppressive, unscrupulous, or substantially injurious to consumers. A party will be guilty under the statute when they engage in conduct which amounts to an inequitable assertion of their position or power over the other party. The definition for deceptive means a capacity or tendency to deceive. However, proof of actual deception is not required all that needs to be shown is that the act had the capacity to deceive the person. But at this point, it should be noted that although actual reliance is not technically a requirement, no case has been decided in favor of a claimant without this actual reliance on the deceptive act. Further, good faith on the part of the actor is irrelevant, so their intention doesn't matter, and good faith will not be a defense. And unfairness is broader then and includes the concept of deceptiveness, but only one is required in order to prevail. A claimant does not need to prove both unfairness and deceptiveness. When courts are trying to decide if something is unfair or deceptive, they're going to look at the circumstances of each case, and they do recognize that no precise definition is possible. So in order to determine it, they're going to look at the facts as compared to the background of actual human experience. And the two main things they look at are the impact in the marketplace and the effect on the average consumer. And so then for the second prong, Selenge is going to talk about the commerce definition.
Commerce definition. In order to prove the prima facie case, the plaintiff must prove the defendant's act was actually in a commerce, surrounding commerce. So the definition of commerce will be it's some type of exchange where the parties are sellers. And also it must not be important, there mustn't be important about the contract. The most important thing in here is whether the defendant's action was allegedly a deceptive act affected the commerce.
And before we move on to the third part of this test, if you go back and you look at some of the things that Leslie said about how courts look to see if an act is, to determine whether an act is unfair or deceptive, you really see how focused on society the statute really is. It's pure public policy here, and the fact that judges and courts are looking to see if something offends human nature or what are the act's effect on a consumer. You see that more so than a number of laws that we have. This act is really focused on protecting individuals, average people on a daily basis, and that's kind of something as we've studied the statute that we've taken away, that it's really there to safeguard our communities, and we find it pretty important.
All right, and the last part of the three-part test is there must be a causal requirement between the act and the damages that resulted. And this can happen in a variety of ways. One of the most common is the loss of specific property or the depreciation of the value of a property. And like Leslie was saying before, generally the reliance on the defendant's act is not necessary to show proximate cause. But in a case where the reliance causes a causal link between the damages and the act, then it could be necessary, but even then the reliance doesn't need to be reasonable, it just needs to be a reliance. And an exception to this general rule is when a claim is based on an alleged misrepresentation by the defendant. If that is the only causal link between the act and the damages, then there must be reliance in that case.
And as we were discussing at the beginning, there are several caveats to making out a prima facie case under 75 1.1. The first, as we talked about earlier, is that the statute does have a burden shifting scheme. It's on the person claiming that they were on the bad end of an unfair deceptive trade act to prove the three elements that we just discussed, that it was an act affecting commerce, that it caused their damages, and that it was an unfair and deceptive act. But once they make that case out, the burden then shifts over to the defendant to prove that he is exempted from the statute. And that gets us to the second caveat here, and that's there's one very narrow exception to the statute, and that's the professional training exception. And basically, if you're part of what the courts and the state legislature have termed a learned profession, you're a medical doctor, you're a lawyer, you're part of the clergy, any transaction in which takes place within your learned area, any of those actions are exempt from the statute. And it doesn't mean to say that just because you're a clergyman, you're exempt from the statute completely. I mean, if you went out and sold somebody a car and you treated them unfairly, the statute would still apply to you. It only applies to actions that you take under your title as a member of a learned profession.
Okay.
And moving on, we're going to talk about how the statute handles questions of law and fact. And this is another thing that's kind of interesting about 75.1.1 is the fact that any actions brought into this basically become bifurcated. First, you have a jury, and they decide the questions of fact, whether or not what actually happened in the situation. Did someone actually sell a car? Was there a contract? What amount? What was damaged? Those type of questions. And then once they determine the facts, it moves on to a second stage where the judge hears those facts and then applies the law to decide whether the act that was committed in those facts was actually an unfair and deceptive trade act. So it's kind of a unique split system for the statute.
The last part that we're going to talk about is damages, and this is obviously the most important part for the plaintiff, but it's also what really makes this statute stand out, and that's the fact that if a violation is found, the plaintiff is entitled to treble damages, which means that the damages found will be tripled. And the reason that this statute is punitive like this is because courts found that the other remedies for fraud or breach of contract or breach of warranty were really ineffective in these certain types of unfair and deceptive scenarios. So they chose to statutorily impose treble damages. A couple of things to keep in mind when thinking about treble damages is the economic factor on the defendant when he's involved in a case that has an unfair and deceptive trade practice claim. And that is that it's going to be encouraging for the defendant to settle because they're going to have to pay a big price if they don't settle, if they allow the court to decide and the plaintiff wins. And so that really encourages settlement. Also, it makes it more rational for a lot of plaintiffs to bring lawsuits civilly because their potential reward is greater, and so they're more likely to actually go out and try to exact this brand of justice through this statute. There are some limitations to the idea of treble damages. The one is that you can't raise the claim as a post-trial motion, so you can't raise the claim after a verdict has already been brought down. And this is kind of the rationale behind that is that courts, while they want to punish the defendant, or if they are a violator with treble damages, they still want to give them an opportunity to settle outside of court and to be able to defend. So in order to bring this claim, you have to raise it early in the trial, and it's best to bring it at the beginning of the trial, because even if you bring it in the middle of the trial, the court could still not allow it, and the test for that is whether or not it would be unfair against the defendant to do so. So in order to bring this claim successfully, it's best just to start it right at the beginning of the lawsuit and just go ahead and get it out of the way. And then the last limitation on treble damages is the disfavor on double recovery, and that is that only the damages for the unfair and deceptive trade practice are the ones that are going to be trebled, and any other damages that are received under the common law claim, which this statute is often brought with, won't be trebled, because courts don't want to give out double recovery for this what's essentially the same act.
As Will was saying, treble damages is a very significant reason for plaintiffs to go ahead and tack this cause of action onto their common law cause of action when they do have a claim. However, there is also the potential of being awarded attorney's fees as an incentive to bring this suit. However, from the outset, I want to point out that treble damages are required under statute. If an action is found under Chapter 75, then treble damages are automatic. They're not at the discretion of the judge. However, attorney's fees are at the discretion of the judge, and in his discretion, he can allow reasonable attorney's fees to the prevailing party, but one of two things must be shown. Either the party charged with the violation must have willfully engaged in the act or practice, and then there was an unwanted refusal by that party to fully resolve the matter, or the party that instituted the action knew or should have known that the action was frivolous and malicious. And just to touch on some of the requirements, the plaintiff obviously must prevail in order to be awarded attorney's fees, but they also must show actual damages, which means that there has to be an actual injury in order to be awarded these fees. When determining if the amount is reasonable, a trial judge is going to look at time and labor expended by the attorney, the skill required to perform the services rendered, the experience and ability of the attorney, and the customary fee for like work when determining if that amount is reasonable.
And so, as you can see, we've kind of finished our checklist here of kind of the nuts and bolts of what you need to to bring a case under 75 1.1. And before we kind of move into our practical application aspect of our discussion today, we have a very special treat for you. We've been blessed here to have an international law student from Mongolia with us, and Munkhselenge today is going to talk to you kind of about how unfair and deceptive trade practices are looked at under Mongolian law.
Hello everybody. So from here there's going to be talk about the Mongolia, where how the unfair and deceptive trade practice is legislated in Mongolia. Before moving to the talking, I met to my professor, one of my professor in the law school at National University of Mongolia. She is in a criminal law department. Her name is Padma. And I met talking with her by the telephone and made the recording, and she told me that under criminal law there are 6 sections for unfair and deceptive trade practices, and one which will be conduct of prohibited manufacturing services and sales. The second one is conduct unlawful activity in the name of manufacture, service and sales. The third one is illegal usage of trademark and name of a company. The fourth is deceiving actions toward consumers. Fifth one is sell unqualified or rejected goods. Sixth one is sell unqualified food products. So under these 6 sections, there is going to be sanctions about fine, arrest, or deterrent. And these sanctions apply to individuals who made these unfair, deceptive things. And also there are other laws which regulates the unfair and deceptive trade. There are, for example, consumer protection law, also the competition law. But the competition law is just legislated in 2010. Before that, there was antitrust law, but now they are going to have the competition law.
And Munkhselenge, did you say that people under those 6 causes of action there can be arrested?
Yes, arrested. Actually, they can be arrested for 2 years in prison, or deterred from 3 to 6 months.
Thank you. And as you can see, the way other countries look at unfair and deceptive trade acts can differ drastically. And I wonder how many used car salesmen we would have in this country if you could spend 2 years in jail for an unfair and deceptive trade act. And so thank you again, Munkhselenge, for that. It's very interesting. And now we're going to actually move on to what we hope becomes what you really take away from this discussion today. You've kind of seen an overview of how the statute works, making out the prima facie case. But now is the part of the discussion where we want you to be able to look at these things and learn how to practically use this, so that you can take the stuff you've learned today, and if somebody came into your office tomorrow, you would be able to help them file an unfair and deceptive claim. And so when thinking about this, some of the things that should be setting off red flags in your mind when a client comes in and starts to tell you a scenario are things like fraud. Am I hearing any mention of fraud? Fraud in the inducement. Did someone trick them in to entering into an agreement? Things like breach of warranty or a breach of a contract. And we heard earlier that breach of contract by itself is not necessarily enough to mean that there's an unfair or deceptive trade act. But oftentimes when there is a breach of contract, you're looking for other egregious conduct that goes beyond just merely breaching the contract. And so oftentimes hearing about a breach indicates that there might be an unfair or deceptive act. And again, coercive tactics. If you're hearing a client tell you about how someone, rode them and forced them into an agreement they weren't really sure on making, a sale that they didn't really want to enter into themselves, that should set off in your mind, hey, 75 1.1 might be able to apply here. And also negligent misrepresentation. And as you can see, all these things are setting off ideas of bad public policy in your head. So once you start hearing that type of evidence, you realize, man, I might have an unfair and deceptive claim. And today we've put together some scenarios for you of fact patterns that have been pulled from actual North Carolina cases. And we'll have some videos here, some client videos, if you will, coming in to ask us at our firm whether or not we could help them with a claim that has with a situation that has arisen.
So what we're going to ask of you is to go ahead and listen to the fact pattern, and then we're going to take an interactive poll through your cell phones. So if you all want to get your cell phones out and get ready to do that, it's a really simple yes or no question. We know you're not experts yet, but we just want to see what we've taught you today, if you can decide if there's a claim or not.
And so, I hate going to presentations or talks where you just sit there and you listen to someone boring talk the whole time. So we wanted to have some type of interaction here, and we felt that if you could look at these real fact patterns, and it really brings home sometimes how hard it is to tell if there is an unfair or deceptive act. And so we've created this polling through a website, and you'll be able to text in yes or no, and we'll do a little real-time actions and be able to see, were we right or were we wrong here. So the first one, if you want to go ahead.
Okay, let's hear from our first person.
I thought Candace was going first.
All right, I own a truck driving industry, Wolfpack Industries, and we signed a contract with this big corporation, Dummy Corp, a few years ago. Now, what I do is I provide an interstate transportation from their plants in Wilmington, North Carolina, all the way to their warehouses in Greensboro. Now, we had this termination clause in our contract that provided that if the party wanted to terminate the contract, we had to give a 60-day notice to the other party. Well, I find out in November that they're trying to find lower bidders. So they give me an opportunity afterwards to bid for it, but I'm not the lowest bidder, and so then they provide me with the 60-day notice of termination of contract. But I still feel like I still feel like they breached the spirit of the contract. Can you help me?
And so now Will's going to pull up our polling site here, and the way this works, if you'll pull it up. Okay, so if you text 222333, yes, not the right one.
Yeah, wrong side. Hold on. There we go.
There we go. Okay, so again, the code you're texting into is 22333, and if you think yes, you type in that code, and if you think no, you type in that code. But we're wondering, does Elliott he have a claim under 75 1.1 from what you've learned today? Are we all in? It looks like the most of you said no, and congratulations, you're all wonderful law students.
It's even going up.
You're all wonderful law students today, and you listened to the presentation, and you knew that breach of a contract alone did not amount to an unfair and deceptive trade act. There was nothing in their contract that said that that they couldn't go out and look for lower bidders, and this was actually pulled from a real case, Tar Heel Industries versus DuPont Corporation, a 1988 North Carolina Court of Appeals case. And in that, very similar facts, trucking company running freight for a corporation had the 60-day termination clause, but they felt that, Tar Heel Industries felt that behind their back, DuPont had gone out, tried to find lower bidders, but DuPont gave them a chance to bid, they didn't bid the lowest, and then they honored the contract and provided 60 days notice and then went with the next lowest bidder. So nothing unfair or deceptive under 75 1.1.
All right, now that we've heard from them, let's hear from our next person.
3 years ago, I sold a dump truck, a trailer, a loader, a backhoe, and a bulldozer to Lewis Green. He paid me up front for all those items except for the bulldozer, and he promised me when he sold the bulldozer he would pay me $7,000. As of yet, he has yet to pay me for this bulldozer. I even called his boss, Richard, to see what Lewis has been up to and see if he's actually been trying to sell this bulldozer. Richard was very vague in his answers and led me to believe that something was awry. I moonlight as an unlicensed private detective, so I decided to turn my skills onto the matter and investigate into the situation further. I kept calling him every month for 3 years, and he just never owned up to selling it, but I knew he had sold it. But I had no hard evidence. Then one day, I saw the bulldozer for sale in a used car lot in another county, and I called Lewis to see if he was trying to scam me. I wanted to catch him in a lie, so the next time I talked to him, I recorded our phone conversation. Even though I had this proof that he was lying, he still wouldn't give me the money for the bulldozer. Can you please help me?
And what do we think here? Does Alex have a claim?
Okay, so fortunate for Alex, he can prevail on this claim. What makes this different than the case we looked at right before this is that, it's okay, y'all are just learning, is that this breach of contract includes some aggravating circumstances that are going to take it over just that common law breach of contract claim and let him prevail on the 75 1.1 claim. The defendant lied to Alex multiple times. He also forged a bill of sale to try to convince Alex that this bulldozer hadn't been sold. And then he also deprived Alex of money for 3 years that he was owed for the bulldozer. So these facts all together add up to aggravating circumstances which would let him prevail. Something that should be noted about this case is that when the same fact pattern is going to produce both a breach of contract and an unfair and deceptive trade act, the plaintiff can elect damages for one but not both. That was mentioned earlier. But in this case, the defendant actually tried to cure the breach of contract so that Alex couldn't prevail on the treble damages, but the court said that it's up to the plaintiff to choose which route they're going to go, so Alex could get treble damages.
And as you can see from our poll here, a 50-50 split on whether or not we thought he could prevail just shows you how tricky and uncertain it can be from situation to situation under 75 1.1. And that's kind of what we were talking about earlier, is that it's hard to pin down what exactly constitutes an unfair or deceptive trade act. And that becomes the biggest problem for attorneys in deciding whether to tack this claim on. And as you can see, it really does. It's just the slightest detail sometimes can push it over the edge.
All right, let's move on to the next one. Let's see.
I run a marina and I provide storage, docking space, supplies, and repairs for boats in Morehead City. 6 months ago, a couple was traveling from Connecticut to Florida and temporarily docked at my marina to refuel. A big storm had hit their boat and caused repairs, which ruined their trip to Florida. The owner of the boat asked if they could leave their boat at my marina for a few months until they could return on their trip to Florida. I explained to him my marina was temporary and boats could only stay overnight. He asked what he could do to allow the boat to stay longer, and I told him that if he had repairs done, such as repainting the hull, that he could stay for 2 to 3 weeks. He signed an authorization formally authorizing the repairs, and I provided him an estimate. He left the boat there for 2 months, and I completed the repairs. But during the repairs, I found out that the storm had done more damage than I'd originally estimated. I completed the repairs, and it cost $500 more than my original estimate. Now the boat owner refuses to pay because he claims that I deceived him. Can you help me?
All right, guys, when you do this one, make sure, I don't know if you noticed, but this time we've heard from someone who's had a claim brought against them for unfair and deceptive trade practices, so we want to make sure, let's see, next. So we want to say, can Candace successfully defend against a claim?
In other words, were her actions, did they amount to an unfair or deceptive trade act? All right, and it looks like the people have spoken here, and you would be right. She would be able to successfully defend against this claim. This comes from another North Carolina case, Robb and Son Boatyard versus Bristol, and a case that actually ended up going federal. But basically here, we see that she entered into a contract with the boat owner. She provided him with a written authorization form detailing the repairs, the specific repairs. She gave him an estimate. When she was doing those specific repairs, not extra repairs, but she realized it was going to take more manpower, a little more labor to fix the boat the way it needed to be fixed. And it only cost $500 more. And in the grand scheme of things, in that case, the bill was thousands of dollars. So $500, it wasn't like the extra repairs cost the boat owner $20,000 extra or something. It was a minuscule fee in comparison to the whole final amount that was due. So the courts held that this didn't amount to an unfair deceptive trade act. She wasn't trying to deceive anybody. She was just trying to perform the repairs as she had agreed to with the owner. So congratulations, you're right again.
All right, here's our next one.
My family and I were looking to move into a new house in the suburbs with one of those development things where they build all the different houses that are the same. So we chose the Mayberry floor plan because we liked the way it was, but we wanted some extra things. Like we wanted a deck and a garage and a fireplace And when we finally moved in, they didn't build it at all like they told us they were going to. It didn't match the brochure. It didn't match our customizations. And the garage was incredibly small. When you pulled your car in, you could not even open up the doors. It's like when you go into a parking lot at the store and you park so close to a car, you can't open the door and you have to park in another spot. That was like my house every day. And then they built this deck and they didn't even build it in the right place. Oh, and I forgot, when I would park my car in the garage, if I wanted to get in the house, I couldn't because it blocked the door. So I could never unload groceries ever. But back to the deck, they built it in the wrong place, and that was just not okay. And it was even smaller than we said we wanted it. And then the driveway had all these depressions in it. So when it rained, they filled up with water and made all these little puddles everywhere. And then I, of all people, tried to fill those in with concrete, which just didn't work. And I can't afford to fix all of these things wrong with my house myself. So can you please help me get my money back from the developer so I can fix all of these and have a safe, comfortable home to live in?
So can Gretchen bring a claim based on that situation she found herself in?
All right, well, it looks like you guys did a good job picking up on some of the key facts in here, which were actually a little bit buried in that scenario. In that scenario, really the key facts were that the vendor, salesman, the person who said that they would build her home, misled her into believing what was going to be involved with the deck and with the garage and with the driveway. But not only did the vendor mislead her, but she also noted that there was a sales brochure that didn't match the layout of what she eventually got, and that there were blueprints for the home, for the floor plan that she got, and so those didn't match. And so this is based on a real case, based on a very similar fact scenario, and the court held that all of those misrepresentations together, the vendor, the brochure, and the blueprints, added up to unfair and deceptive trade practice, because it wasn't just a mistake on the part of the seller that the home didn't match or the deck was built improperly or something like that, because the court could look at all of the circumstances together and realize that in this case the vendor was misleading the plaintiff in this case. Okay, so let's...
Okay, so I just moved back into town, Winston-Salem, and just got a job as a substitute teacher at my old high school. And I've been saving up my money, and I had my eye on this 67 Shelby Mustang. Sweet, sweet car. So I went down to Ashley Schaefer BMW, and not the straightest shooter, but I saw he had a 67 Shelby and wanted to check it out. So I looked at the car, looked pretty good, except there was a panel that mismatched on the back of it. And I made sure, I specifically asked Mr. Schaefer if the car had been in any kind of accident or anything, why the panel was mismatching. He told me that, just something that happened. It wasn't any history of accidents, no damage or anything, just didn't match. So I thought about it, and I really wanted the car, and so I went ahead and bought it. When I bought it, they made me sign a contract saying that I bought the car as is, no warranty or anything. And I decided I was going to take it to my buddy Stevie. And Stevie was going to paint it for me because I didn't really like the color, and I wanted to deal with the the mismatch. I didn't like that. And as soon as Stevie looked at it, he told me that just hands down, obviously it had been in a serious accident. So is there anything you can do to help me?
So here again, can Jordan bring a successful claim under 75-1.1?
So as a result, the question was there, is it an unfair deceptive trade practice? The answer is yes. There was a unfair trade practice because the seller, he said that there wasn't any accident before. It was like a new car. There wasn't any accident, any wreck, anything. But the buyer, after buying it several times later, he found out that it had an accident in the car. So in order to sell to car to the buyer, the seller lied or gave mislead statement to the buyer. So it is going to be unfair and trade deceptive practice act under the North Carolina law.
It is important to to pull out here that from the real case, that the reason that this was an unfair and deceptive trade act was that the plaintiff was able to produce evidence that showed that the car salesman actually affirmatively knew that the car had been in a wreck. It wasn't just that he didn't think there had been no accident. He knew that it had been in a wreck, and he just flat out lied to the buyer. And so the court found that to be egregious conduct under 75-1.1.
And this intentional misleading and lying is kind of a theme throughout these cases. So when someone intentionally and knowingly is going to mislead or lie to you, such as telling you affirmatively a car hasn't been in an accident or lying about selling a bulldozer, that's a huge red flag, and that's going to amount to an unfair deceptive trade practice.
Okay, all right, now we're going to hear from our last person.
My husband Steve and I moved to Winston-Salem a couple of years ago, and we searched and searched for the ideal home for our family. We've had realtors, we've had friends help us. We finally found a terrific subdivision with the best schools. So it's a new subdivision. We talked to the builder. The builder gave us a reservation agreement. We gave the builder $500 and signed this agreement. We were under the impression that this agreement, which expressly stated, gave us a right to build in that subdivision. Well, 6 or 8 months later, we get a call from the developer who indicates that he's been unable to secure the permits. I don't recall anything in that agreement about permits being an issue. He gave us our $500 back, but I don't know how we'll find another place now. We spent such a long time trying to find just the perfect place. I feel horribly wrong. We feel deceived, and we feel like he should have been more honest with us.
Okay, guys, same thing. Can Ellen bring a successful claim for unfair and deceptive trade practices? All right. Well, it looks like so far everybody's correct, and that's really good. This is one of the real kind of classic. Well, maybe not. Almost everybody. Enough.
Professor Nichols must have weighed in.
This is really just one of those classic cases where the client is very sympathetic. Really, something obviously bad has happened to them, but really in this case, what just happened was just merely a breach of contract. The homeowner developer just really did not hold up their end of the bargain, and it wasn't an unfair, deceptive trade practice in this case. And so that's one of the things we really need to watch out for is do the facts of the situation really amount to the unfair, deceptive trade practice, and not necessarily what is the result of the facts to the client, because it really matters what happens before and during when the practice takes place.
All right, well, that'll conclude our presentation today, and we hope that you would get a brief overview here of what 75-1.1 looks like, some of the things that you need to bring a claim under that statute, and then really what practical use can we gain from this statute. And I hope that some of these scenarios we appreciate you participating in that polling exercise, but kind of really get you thinking about the types of situations you're going to see in your everyday practice, and whether those types of situations do or do not amount to an unfair, deceptive trade practice. And so for you as you leave today, we've put together a wiki book on North Carolina General Statute 75-1.1, and I have to say that we all did the research and broke it down so that it would be an easy to use guide for you in your own practice. More in depth, it goes far more in depth than we could here today in this discussion, but it'll be a really nice guide to have for you in your own practice as you go out there. When someone comes in your office, you can say, hey, let me look at this book, this wiki book here, and see if this might be a claim that I can tack onto something already. There's more cases similar to the ones we went through today in the scenario, and it just really is quite a useful tool. Leslie did an incredible job of putting this together and editing it, and we hope that it's something that you can actually make use of in your everyday practice. So thanks for being here today.
Thank you.